What if I told you that one legal belief you hold, something you think is an obvious truth, could actually land you behind bars? It sounds like the plot of a thriller, but this is the harsh reality facing thousands of people who fall victim to common legal myths. Today, we are breaking down the 50 most dangerous legal misconceptions, beliefs that could genuinely cost you your freedom. Stick with us until the end, and you'll learn how to avoid falling into a legal trap due to simple lack of awareness and what the law actually says. By the way, what's the craziest legal myth you've ever heard? Drop a comment below right now, even before we dive in. Let's see if it makes our list. So where do these myths actually come from? Mainly from two sources, Hollywood and word of mouth. Hollywood blockbusters and crime dramas have created an entire body of movie law in our heads, rules that work beautifully for drama, but have zero connection to reality. The cop who bursts into a house without a warrant screaming, "I have probable cause," or the lawyer who finds the smoking gun at the last second and yells, "Objection." These are effective, but completely fictional scenes. The second source is advice from friends, acquaintances, and online forums where everyone is an armchair legal expert. That classic phrase, "my buddy who knows a guy told me," that's often the beginning of a major headache. In this video, we're going to separate fact from fiction and arm you with real knowledge. Because in the world of law, ignorance is no excuse, and following bad advice can easily make a bad situation worse. We begin with the classic scenario we've all internalized from Hollywood cinema, the enduring myth that if police fail to read you your rights upon arrest, the entire case is automatically dismissed. It sounds like a magic bullet that instantly dissolves all legal trouble, doesn't it? Many people genuinely believe this procedural error is their guaranteed get-out-of-jail-free card. But the reality, as always, is far more complex and much stricter. In the legal systems of many countries, the procedure for advising a suspect of their rights is indeed critical, but failing to perform it does not lead to an automatic dismissal of the charges. This is simply a procedural violation. What does that mean in practice? It means that any evidence gathered after your detention and before you were properly advised of your rights, say your confession, might be ruled inadmissible by the court. Crucially, however, this doesn't invalidate all the other evidence against you. If the investigators have witness testimonies, video footage, or forensic evidence, all of that remains perfectly valid and admissible in court. Your freedom is still very much at risk. Believing this myth can give you a dangerous false sense of security, causing you to be careless with your words and actions immediately following arrest. Picture the movie scene. The cops forget the rights, and the villain smirks. Now transition to the realistic graphic. The word confession is crossed out in red, while video, witnesses, and forensics remain, circled in solid green. The next dangerous misconception is that the police can never enter your home or search your car without a warrant. This myth is based on the concept of the sanctity of the home, and while it's partially true, the devil, as always, is in the details. The law absolutely protects your private space, but there are countless exceptions the movies never tell you about. For example, if an officer sees a crime being committed through a window or hears screams for help, they have the right to enter without a warrant to stop the offence or rescue people. This is known as exigent circumstances. The same rule applies to your vehicle. If the officer has probable cause to believe that your car contains instruments of a crime, illegal drugs, or stolen property, they can conduct an immediate search on the spot. This might be if the interior smells strongly of illegal substances, or if a weapon is clearly visible on the seat. Believing in absolute immunity without a warrant could lead you to aggressively obstruct lawful police actions. This in itself is a violation, and can even lead to criminal charges for resisting arrest or obstructing an officer. Visual cue description follows. Visually, we could show an icon of a warrant with a padlock on it. Beside it, exception icons appear, such as screams for help, weapon in plain view, or hot pursuit, causing the padlock to unlock. Myth number 3. I can refuse a sobriety test without serious consequences. Some drivers mistakenly believe that if they refuse to blow into the machine or decline a medical blood draw, they can successfully skirt a driving under the influence penalty because there will be no hard evidence of impairment. Let me be absolutely clear. This is one of the costliest mistakes you can possibly make behind the wheel. In the legal systems of most jurisdictions, refusing a chemical or field sobriety test is, by itself, defined as a severe legal violation. Under the law of implied consent, this refusal is automatically treated as an admission of guilt. The penalties for refusing the test are identical to the penalties for a confirmed DUI or DWI conviction, immediate massive fines, and lengthy suspension of your driving privileges. Think about that. By refusing the test, you don't evade punishment. You guarantee the maximum penalty, even if you were completely sober. This strict rule exists for a simple reason: to prevent impaired drivers from simply stalling for time until the alcohol clears their system. Therefore, if you are truly confident in your sobriety, refusal is the absolute worst strategy you can employ. Believing this myth will cost you your license and thousands of dollars in legal fees and increased insurance rates. Imagine the scales of justice balanced before you. On one side, you have taking the test. That path has two outcomes. One, you are sober and you walk away, consequence-free. 2, you are impaired and you face license suspension. On the opposite side, you have refusing the test. That path has only one outcome, and it is absolute, guaranteed loss of driving privileges regardless of whether you were drunk or sober. Our fourth common misconception is the belief that silence means consent. We've heard this phrase since childhood, but legally speaking, it often doesn't hold water, and relying on it can be downright dangerous. In criminal law, you are protected by the right to remain silent, ensuring you don't have to testify against yourself. Your silence during an interrogation cannot be interpreted as an admission of guilt. However, things get significantly trickier in civil and administrative cases. If you receive an official letter, a formal claim, or a notice and simply choose to ignore it, your silence might indeed be interpreted as acceptance of the facts or demands outlined within. For example, imagine a contractor sends you a statement of work completed. If you fail to sign it or send a documented rejection within the required time frame, a court may rule that you accepted the work without complaint or reservation. Similarly, if an online service changes its terms and conditions and notifies you, but you continue to use the service without voicing any objection, you have implicitly accepted the new rules. The belief that simply remaining silent will cause the problem to disappear often leads directly to costly lawsuits and significant financial losses. Think of a comic strip illustration. A person receives a letter stamped "legal claim," shrugs, and tosses it into the trash. The very next panel shows a judge banging his gavel, ruling decisively against the silent party. Myth number 5. If I delete files from my computer or format the drive, no one will ever find them. In the digital age, many people mistakenly believe that hitting the delete button or formatting a drive is a surefire way to permanently eliminate compromising information. This is a profoundly dangerous misconception. When you delete a file, the operating system doesn't actually wipe it physically from the disk. Instead, it simply marks the location that file occupied as free space, ready for new data to be written. The file itself, which consists of zeros and ones, remains on the disk until new information is recorded over it. Specialized forensic software used by law enforcement can easily recover this so-called deleted data. Even disk formatting, particularly a quick format, does not always guarantee the complete destruction of information. There are advanced digital forensic analysis techniques capable of recovering data even after several overwrite cycles. Attempting to conceal evidence in this manner is not only ineffective, but it can also be viewed as obstruction of justice, a separate offence that will severely aggravate your legal situation. Visually, this can be demonstrated as follows: an animation where a file moves to the recycling bin, the bin is emptied, but beneath the surface of the hard drive, the file remains as a digital ghost, which is then illuminated by recovery software. The sixth misconception stems from the saying, "My home is my castle," and it's the belief that I can do whatever I want in my own house. While the right to privacy and the sanctity of your home is fundamental, it is not absolute. Your freedom ends where it infringes upon the rights of others or violates the law. You can't blast loud music in the middle of the night, disturbing the peace and ignoring noise ordinances without consequence. You are also prohibited from turning your apartment into a drug lab, a brothel, or an illegal weapons cache. If your actions pose a threat to those around you, say, you start dangerous structural renovations that could cause the building to collapse, or allow unsanitary conditions to develop that endanger the entire residence, authorities have every right to step in. Furthermore, the police can enter your home without a warrant if they have sufficient probable cause to believe that a crime is being committed inside. Believing that the walls of your apartment grant you full legal immunity is a direct path to massive fines, community service, and in the most egregious cases, court-ordered eviction. To visualize this, imagine a building shown in cross-section. In one apartment, a person is quietly reading, no problem there. In the unit next door, music is pounding, visualized as red sound waves slamming into the neighbor's wall, prompting that furious neighbor to call the police. The seventh common myth often surfacing in arguments and conflicts is that saying, "I was just joking," provides a universal defense against accusations of threats or insults. Many people genuinely believe that adding this phrase after an aggressive statement completely negates their liability. That is simply not true. The law evaluates not your personal intentions, but how your words were perceived by the victim, and whether those words could reasonably be interpreted as a genuine threat. If you describe in detail how you plan to harm a person, their health, or their property, and the victim has reasonable grounds to fear the execution of that threat, that may be sufficient grounds for criminal charges. The court will analyse the entire context, the tone of the conversation, your existing relationship with the victim, and even your reputation. The phrase, "it was just a joke," will not be your lifesaver if all the surrounding circumstances point to the seriousness of your intent. The same principle applies to insults, especially those made publicly or online. If you degrade a person's honour and dignity using explicitly indecent language, claiming humour will not protect you from a defamation lawsuit or even administrative penalties. Picture a chat where one user types out explicit, terrifying threats only to finish the message with a smiley face and the words, "I'm just messing with you." The judge looks at that screenshot, shakes their head, and delivers a guilty verdict. The eighth misconception is believing in the saying, "finders keepers, losers weepers," or the idea that if I found something, it automatically belongs to me. This childhood rhyme has absolutely nothing to do with the law, specifically the Civil Code. If you find a wallet, phone, or any other valuable item on the street, you do not become its owner. Legally, you are required to take steps to find the rightful owner. You must report the finding to the police or to a local governmental authority. If the item was found on public transport or within a private establishment, like a cafe or shop, you should hand it over to a representative of that venue's owner. Taking ownership of the item, especially if you knew or could easily have determined the owner but chose not to, can be classified as theft. For instance, if the wallet you found contained documents or bank cards that made the owner easy to identify, but you simply took the cash for yourself, you've committed a crime. While you're entitled to a reward for returning the item, often up to 20% of the item's value, you only qualify if you followed the law and successfully returned it to the owner. Believing that a found item automatically becomes your property is the fastest way to turn yourself from an honest citizen into a criminal. Picture this. A person finds a phone on a park bench. An illustration appears above their head, showing two paths, the police station icon, which is the right way, and the pocket icon, which is the wrong way, leading directly to handcuffs. Myth number 9, and one of the most dangerous, relates to self-defense. The idea that, if I'm attacked, I can use any force necessary to protect myself. The concept of necessary defense is certainly codified in law, but it is strictly limited by the principle of using excessive force. This means your defense must always be proportional to the attack. If someone attacks you with their fists, and you respond by using a knife or a firearm, that will highly likely be deemed a use of excessive force. You could then find yourself in the defendant's chair, facing serious charges, potentially for aggravated assault or even manslaughter. The law requires that the threat be both real and imminent, meaning the danger must be happening right now. You cannot retaliate against an aggressor after the conflict has ended. That ceases to be self-defense and becomes a deliberate criminal act. Case law regarding self-defense is notoriously complex. The line between lawful defense and criminal action is incredibly fine. Every instance is judged individually, taking into account all the circumstances, the disparity of force, the location, the timing, and the nature of the threat. Believing you have carte blanche to use unlimited violence in response to aggression is a direct path to prison. We can visualize this using scales. On one side, the aggressor's fist, the threat. On the other, the defender's fist, a proportional response. Now imagine a second set of scales, a fist on one side and a pistol on the other. That massive imbalance sharply breaks the scales, illustrating the failure of proportionality. Myth number 10, widely accepted both in business and everyday life, is this: a verbal agreement holds the same weight as a written contract. People often say, "But we agreed. He gave his word." Unfortunately, in court, mere words carry very little weight unless they are properly documented. For many types of transactions, the law explicitly requires a written form. For example, loan agreements exceeding a certain limit, leases lasting longer than a year, and the sale of real estate. All of these must be formalized on paper, even when the law doesn't mandate a written agreement. Proving the terms of an oral deal in court is extremely difficult. You would need witnesses, audio recordings, the legality of which can be problematic, or circumstantial evidence such as correspondence or emails. If your opponent simply denies the agreement, saying nothing of the sort happened, and all you have is your word against theirs, the court will likely dismiss your claim. Relying on verbal promises, especially when money, property, or significant obligations are involved, is a massive gamble. The rule is simple. All important agreements must be put in writing, signed by both parties, and clearly state all essential terms and conditions. Visual cue. Two people shake hands over a desk. The scene then shifts to a courtroom, where one party looks bewildered, throwing their hands up before the judge, while the second smiles smugly. Misconception number 11. The idea that I can't be punished if I didn't know the law. This belief directly contradicts one of the most fundamental principles of jurisprudence. Ignorance of the law is no excuse. The state operates under the presumption that all citizens know, or are expected to know, the published laws. Once legislation is officially made public, everyone is considered to have been notified. You cannot walk into a courtroom and claim, "Your Honour, I didn't know that exceeding the speed limit by 50 kilometers per hour would result in the loss of my driving privileges," or "I wasn't aware that downloading pirated content carried a fine." That argument will simply not be accepted. Now, of course, there are nuances related to criminal intent. For certain offences, the prosecution must prove that the individual acted deliberately, fully aware that their actions were illegal. But in the vast majority of cases, especially under administrative law, covering things like fines, traffic violations, and taxes, your personal level of legal literacy is irrelevant. If you committed the offence, you will be held accountable. Therefore, adopting the passive stance of "I'm not a lawyer, so I don't need to know this stuff," can end up costing you very dearly. Visualization idea. Picture a person walking blindfolded across a minefield. On every single mine is written an article of the law. They step on one, it explodes, and the text appears. Ignorance provides no protection. Myth 12. Because I hold a foreign passport, I'm somehow exempt from local laws. This is an incredibly dangerous misconception for tourists and expats alike. The moment you step onto foreign soil, you are immediately subject to that country's jurisdiction. Your citizenship doesn't matter. You must obey their laws. Your passport does not grant you immunity. If you break the law, you will be prosecuted under local statutes, and these can be radically different from what you're used to back home. What might be considered a minor misdemeanor in your home country could be classified as a serious crime with severe penalties abroad. Classic examples include strict alcohol prohibitions in Muslim nations, harsh penalties for importing certain medications into places like Singapore or Thailand, and rigid rules governing public behaviour. The only exception to this rule is diplomatic immunity, but this is reserved for an extremely limited circle of individuals. The average tourist or foreign worker does not possess this protection. Before travelling, it is absolutely vital that you research a country's core laws and customs, ensuring that an unintentional action doesn't land you in detention or trigger a foreign court case. To illustrate this point, imagine a map showing a tourist crossing a border. The clothing they wear, symbolising the laws of their home country, instantly switches to apparel accepted in the new nation, while a book titled Local Laws appears clearly above their head. Myth number 13. Once I've paid my taxes, the state can't demand anything else from me. Paying taxes is certainly one of a citizen's primary obligations, but it is far from the only one. The state regulates numerous other aspects of our lives. These include mandatory military service, the duty to obey general laws and traffic regulations, adherence to sanitary and environmental standards, and the obligation to ensure your children receive an adequate education, among others. Furthermore, beyond taxes, there are various other compulsory payments, fees, duties, and mandatory insurance contributions for pension and compulsory health insurance funds. The belief that timely tax payment grants you an indulgence for everything else is fundamentally mistaken. You might be an exemplary taxpayer, yet still face a hefty fine for illegal parking, be held liable for disturbing public order, or even receive a civil lawsuit from neighbours for damages. The state is a complex system of rules and responsibilities, and taxes, while crucial, represent only one component of that system. Visually, we can imagine this as the tree of citizen duties. The trunk is the Constitution. One large branch is taxes, but many other branches stem from the trunk, including observing laws, defending the homeland, caring for children, and protecting the environment. The 14th misconception concerns the world of social media. I can write anything I want online. That's freedom of speech. Freedom of speech is a fundamental right, but it is not absolute. It stops where defamation, harassment, incitement to extremism, hate speech, and the spread of false information begin. The internet is not a lawless zone. Everything you write on social media, in forums, or in comment sections can have real legal consequences. A post that undermines someone's honour and dignity can result in a lawsuit and a demand for compensation for emotional distress. Sharing, retweeting, or even liking extremist material can make you the subject of a criminal investigation. Spreading deliberately false information that harms the public carries serious legal liability. It is crucial to understand that your social media page is a public space, and you are acting as a publisher. Anonymity online is highly relative, and law enforcement can identify the author of almost any statement if necessary. Before you post something in the heat of the moment, ask yourself if you are ready to defend those words in court. Visual idea: a person typing an angry comment on a laptop. Digital thread stretched from the screen directly into a courtroom where the comment is being read aloud as evidence. Myth number 15. No body, no crime. This grim aphorism, often popularised in crime novels, creates the false impression that a murder cannot be proven without finding the victim's remains. That is absolutely false. Modern forensic science and legal precedent allow juries to issue guilty verdicts in homicide cases even when the victim's body is missing. The prosecution can build its entire case on a strong collection of circumstantial evidence. What kind of evidence are we talking about? For instance, witness testimony regarding a fight or an abduction, cell phone data showing the victim and the suspect were in the same location, or traces of the victim's blood found in the suspect's car or home. We also look for surveillance camera footage and any attempts by the suspect to use the victim's credit cards or phone after their disappearance. If all these pieces and other evidence come together to form a unified, consistent picture proving that a specific person was murdered by a specific perpetrator, the court absolutely can deliver a guilty verdict. Believing this myth gives criminals a false hope of impunity, often leading them to make a fatal mistake. Visual suggestion. Imagine a jigsaw puzzle on screen. The centerpiece labelled "the body" is missing, but all the surrounding pieces, such as witnesses, DNA, video, and motive, are firmly in place, clearly outlining the entire picture of the crime. Misconception number 16. The belief that I have the absolute right to audio or video record anyone without their knowledge or consent. This issue is more relevant than ever, as nearly everyone carries a powerful recording device in their pocket. The law, however, draws a very fine line here. If you are a party to a conversation and you are recording it to protect your own rights, for example, documenting threats or establishing the terms of a verbal agreement, in many jurisdictions, this is legally permissible. This type of recording can often be submitted as evidence in court. However, if you secretly record a conversation between other people, one in which you are not involved, this is generally considered illegal wiretapping or a severe violation of their privacy, and you could face legal consequences. The same principles apply to video recording. Filming in public spaces is usually allowed, but intentionally recording someone's private life inside their home, thereby invading their personal space, is illegal. Furthermore, publishing audio or video that features an identifiable person without their consent can also violate their rights, especially if the primary goal of the publication is to reveal intimate details of their private life. While exceptions exist, for instance, for professional journalistic investigations or when the recording serves a significant public interest, the rule for the average citizen is simple. Recording your own conversation is generally permissible. Secretly recording others' private conversations is not, and publishing someone's image without their permission requires extreme caution. Visual cue summary. Icon of a dictaphone. Arrow points to a scene where two people are talking, and a third person is secretly recording them from the side. Red X. A second arrow points to a scene where one of the two speakers is holding the dictaphone. Green check mark. Myth number 17. If a store displays an item with the wrong, too low price tag, they aren't required to sell it to me at that price. Many of us have faced this exact situation. The shelf says one price, but the scanner at the register rings up a different, higher price. The salesperson usually claims it's a simple mistake and demands you pay the full correct amount. However, under consumer protection laws, the price displayed on the shelf is considered a binding public offer. This means the store is offering to enter into a sales contract under the exact terms, including the price, listed on the tag. The store cannot unilaterally withdraw this offer once it has been made. Your right as a consumer is to demand that the item be sold to you at the price you saw displayed. If the salesperson refuses, you should ask to speak to a manager, take clear photos of both the price tag and the product, and file a formal complaint with the relevant consumer protection agency. More often than not, once the staff realizes that you are aware of your rights, they will honor the shelf price to avoid further hassle and potential fines. Believing that an erroneous price tag somehow doesn't bind the store prevents you from saving money and asserting your legal rights. For illustration, imagine a customer at the register showing the cashier a photograph of the price tag on their phone. The cashier initially frowns but then sighs heavily and rings up the item at the lower, advertised price. The 18th misconception is the belief that employees are protected from dismissal while on sick leave or vacation. This assertion is generally true, but as with many legal matters, crucial exceptions exist. Employment law does typically prohibit employer-initiated termination during periods of temporary disability or paid annual leave. This is a vital protection intended to prevent unscrupulous managers from firing staff when they are most vulnerable. However, this prohibition only applies when the termination is initiated by the employer. The primary exception is the cessation of business. If the organisation is liquidating or a sole proprietor is ending their operations, all employees will be laid off, including those who are sick or on vacation, provided all established legal procedures and compensation payouts are met. Dismissal is also possible if a fixed-term employment contract naturally expires while you happen to be on leave or ill. In this case, the agreement simply ceases to be in effect. Believing you have absolute invulnerability during sick leave means you are not prepared for these specific situations. The visual idea for this is a calendar where vacation and sick days are highlighted by a protective field. But then, a massive liquidation stamp appears and smashes right through that protective barrier. Misconception number 19. If I find a loophole in the law, I can use it and it will be perfectly legal. People frequently talk about gaps or holes in legislation, believing that if an action isn't explicitly forbidden, it must be allowed. While this foundational legal principle, that which is not prohibited is permitted, does exist, it absolutely does not grant you the right to abuse the law. Courts and regulatory bodies don't just assess the formal compliance of your actions with the letter of the law. They also examine its spirit and underlying purpose. If you use formal loopholes to achieve an obviously illegal goal, say evading taxes or defrauding your counterparties, your actions are likely to be deemed in bad faith. This is where the doctrine of circumvention of the law comes into play. Actions that are formally legal might, when viewed collectively, clearly be designed to achieve an unlawful result. In such cases, the court may deny you protection and apply the consequences that would have occurred had you acted illegally from the outset. For instance, if you establish a chain of purely fictitious transactions just to gain an unwarranted tax advantage, the tax authority can reclassify those transactions and assess significant additional taxes. Trying to game the system by relying on formal gaps often results in much bigger problems than a direct violation would have. Here is the visual analogy. Imagine a person spotting a hole in a fence labelled "the law" and squeezing through it. Waiting on the other side isn't freedom, but a judge holding a sign that reads, "Abuse of right." Myth number 20. A police officer must always be in uniform. Many people believe that if someone approaches them in plain clothes and identifies themselves as a police officer, they can ignore the person or even resist, assuming the officer is off duty. This is a serious mistake. Police officers, especially detectives or those in specialised criminal investigation units, often work in plain clothes to carry out official duties, such as during ongoing investigations or surveillance operations. A police officer is considered to be on duty and carrying out their responsibilities 24 hours a day, 7 days a week. Therefore, even if they are not in uniform, their lawful demands must be complied with. Of course, you have every right to request that they show their official identification or badge and credentials to confirm they are a legitimate law enforcement official and not an imposter. You should examine the ID carefully. You can even call the local precinct or dispatch to verify that the individual is indeed an employee of that agency. However, once you have confirmed their identity, you are legally required to comply with their lawful orders. Refusal to comply or any resistance will carry the same legal consequences as if the officer were wearing a full uniform. Visual idea. A person in plain clothes shows their ID. A powerful glow emanates from the credentials, visually manifesting the outline of a police uniform over the person's body, symbolizing their official authority. Myth number 21. Confession is the queen of evidence. This phrase, often attributed to Stalin's prosecutor, Vyshinsky, is deeply rooted in our collective consciousness. It creates the false impression that once a person admits guilt, their conviction is automatic and the need for further investigation is over. However, modern justice systems operate entirely differently. Under current legislation, a defendant's admission of guilt can only serve as the foundation for an accusation if that guilt is confirmed by the totality of all evidence related to the criminal case. Simply put, your confession alone is worthless unless it is supported by corroborating facts, things like witness testimony, forensic analysis, or physical evidence. This standard is crucial because it protects individuals from self-incrimination, which can occur under duress, intense stress, or when attempting to shield someone else. If you confess to a crime but all the other evidence points toward your innocence, the court is legally obligated to issue an acquittal. Believing in this myth is dangerous because it encourages people to falsely implicate themselves, thinking the outcome is already sealed. To illustrate this concept, imagine the scales of justice. On one pan, you place a sign labelled confession. The other pan remains empty and the scales do not tip. Only when you add the weights, label corroborating evidence and witnesses to that second pan, do the scales finally balance the weight of the confession. Myth number 22. The belief that you can return absolutely anything to the store within 14 days. This is one of the most widely known consumer protection laws, but people often interpret it far too broadly. The law does allow you to exchange or return goods of appropriate quality if they simply don't suit you, maybe because of the shape, size, style, colour, dimensions, or included accessories. But there are crucial conditions. First off, the item must be of suitable quality, meaning it has to be fully functional and undamaged. Secondly, it cannot have been used. It needs to retain its original condition. All consumer properties, the tags, seals, and packaging must be intact. And thirdly, and most crucially, there is a specific list of goods that simply cannot be exchanged or returned for these reasons. This exclusion list often includes complex technical goods, such as smartphones and laptops, personal hygiene items like toothbrushes and combs, perfumes and cosmetics, undergarments, medications, books, and even vehicles. This means if you buy a perfectly working smartphone, only to realise at home that you hate the colour, you likely won't be able to take it back. Believing in the universal power of this 14-day rule is a common path to disappointment and conflict with retailers. Visual description. Imagine a customer trying to return both a toothbrush and a smartphone. The store clerk pulls out a huge list titled Non-Returnable Items, where those specific products are highlighted in red. Myth number 23. If something happens to me at work, my employer is always responsible. An occupational accident is a serious matter, and the employer is indeed required to investigate it, and in most cases provide compensation. However, employer liability is not absolute. The investigation establishes the causes of the incident. If it's proven that the accident occurred solely due to the victim's own gross negligence, the court may reduce the amount of compensation. Furthermore, if the injury was caused by the employee's state of alcohol or drug intoxication, and this state was unrelated to the operational or technological process, the employer may be entirely exempted from liability. Additionally, if an employee violated safety regulations that they acknowledged in writing, for instance, working without a hard hat where one is mandatory, this will also be taken into account when determining the degree of fault. Assuming you can neglect safety protocols and believe the company will foot the bill, if something goes wrong, it's not only foolish, but also dangerous to your life and health. Visual. An employee wearing a hard hat stands as a brick falls, hitting the helmet and bouncing off. The employer pays compensation. Now picture another employee who removes their hard hat and the brick hits their head. A giant question mark hangs over the employer's responsibility. Myth number 24. A lawyer can guarantee a 100% win. Unscrupulous lawyers often try to lure clients by promising a guaranteed win or a 100% successful result. This isn't just unethical, it is strictly prohibited by the Professional Code of Conduct for Attorneys. No honest professional lawyer would ever give you that guarantee. Why is that? Because the outcome of any legal matter hinges on countless factors, many of which are completely outside the attorney's control. These factors include the opposing party's legal strategy, the evidence they present, witness testimonies that can change unexpectedly, the judge's internal convictions, or even sudden changes in legislation or judicial precedent. An attorney's job is not to guarantee a result. It is to do everything possible to protect the client's interests, skillfully drafting legal documents, building a strong legal defense, finding and presenting compelling evidence, and delivering a persuasive argument in court. They can assess the prospects of a case, but this will always be a probabilistic evaluation, a likelihood, not a hard guarantee. Believing promises of a guaranteed result often leads clients to choose an incompetent or dishonest specialist, resulting in a lost case and a waste of money. Imagine this illustration. Two lawyers stand before a client. The ethical one hands over a contract labelled Qualified Legal Assistance. The dishonest one shows a crystal ball that clearly reveals the words 100% victory. That is a clear deception. Myth 25. A police officer can't stop me unless I've broken the law. This misconception is particularly common among pedestrians. A lot of people believe that if they are just walking down the street, the police have no grounds whatsoever to stop them or ask for ID. That's not entirely true. Police legislation grants officers the authority to check identity documents in several specific situations. First, if there is information that gives them reasonable suspicion that you have committed a crime. This could involve matching a description in a bulletin, looking similar to a composite sketch, or exhibiting highly suspicious behaviour. Second, if there is a reason to believe you are a wanted person. Third, if there is a basis to initiate administrative proceedings against you for an offence. For instance, if you are walking unsteadily and smell of alcohol, that could be classified as being intoxicated in a public place. Additionally, ID checks can be performed under special operational measures, such as during a counter-terrorism operation. In short, the police must have a legal basis for the stop, but those grounds are quite broad. Simply stating, "I haven't broken any laws," may not be enough. You certainly have the right to politely ask the officer why you were stopped. However, refusing to present identification can lead to detention until your identity is confirmed. Visual cue description. An officer stops a passerby. Thought bubbles appear above the officer's head with icons representing the legal grounds, a composite sketch, a wanted sign, and a crossed-out bottle. Myth number 26. If I've possessed property for many years, it automatically becomes mine. This misconception centres around the legal concept known as adverse possession, but it is frequently misunderstood. While it is true that the Civil Code, or legal statute, allows for the acquisition of property rights through long-term possession, a very strict set of conditions must be satisfied for this to happen. First, the possession must be in good faith. This means that when you took possession, you genuinely did not know and should not have known that there was another legal owner. If you knowingly and willfully seize someone else's land, your claim immediately fails the good faith test. Second, the possession must be open and notorious. You cannot hide the fact that you are occupying or using the property from the actual owner or the surrounding community. Third, it must be continuous for the full statutory period, 15 years for real estate, and typically 5 years for other types of movable property. And this is the most critical point. Ownership through adverse possession is not automatic. It must be established by a court judgment. You must file a lawsuit, present a claim, and successfully prove that every single one of these strict conditions has been met. The simple fact of using someone else's property for a long time is not enough. Visual cue. Imagine a timeline marked 15 years. A person is pushing a small house toward that finish line, but instead of a deed of ownership waiting for them at the end, they find the steps of a courthouse, which they still have to enter. Myth number 27. Your dashcam or cell phone footage is guaranteed undeniable proof in court. Video evidence is definitely crucial and carries significant weight, but it is not automatically absolute. The court assesses all evidence based on its own internal conviction, which must be formed through a comprehensive, complete, objective, and direct examination of everything available in the case. So what does this mean for your recording? First, the court must confirm its authenticity. This means ensuring the footage hasn't been edited or tampered with. To establish this, technical forensics or expert analysis may be required. Secondly, the court needs to establish the full context, when, where, and under what circumstances the recording was made. Third, the footage must be relevant to the case, meaning it must capture the specific events critical to the proceedings. For instance, in a car accident case, dashcam footage clearly showing the moment of impact and the traffic light signals will be key evidence. However, if the footage is blurry, shot from a poor angle, or doesn't allow for an unambiguous interpretation of events, its evidentiary strength significantly decreases. Furthermore, the court will always weigh the video evidence alongside other pieces of information, such as witness testimony, accident reconstruction diagrams, and the results of forensic examinations. Believing that a single recording will decide the outcome of any case can lead you to neglect gathering other essential evidence. Picture this visually. The video icon is placed on one side of the scales of justice, but to truly tip those scales in your favour, you must add the corresponding weights: authenticity, expert witness, witness statements, and other corroborating evidence. Myth number 28. The misconception that silence or lack of resistance equals consent, especially when discussing sexual relationships. This is one of the most dangerous and damaging misconceptions that utterly destroys lives. Modern legislation worldwide is shifting towards the necessary concept of active consent. This means that consent for any sexual contact must be voluntary, fully informed, and clearly expressed. The absence of the word no does not automatically mean yes. A person may fail to resist due to paralyzing fear, shock, helplessness, coercion, or being in a dependent or vulnerable position. Any sexual contact without active, affirmative consent can and often will be classified as sexual assault or rape. Silence, passivity, or a lack of physical struggle are not, and have never been, synonyms for consent. The courts will always evaluate the totality of circumstances, whether the victim had a genuine opportunity to resist, or whether they were in a compromised state. This myth doesn't just enable violence, it can also land someone in court who genuinely believed that since she didn't scream, she must have been okay with it. Remember this crucial point. Only yes is consent. Everything else is no. Visual description for the voiceover adaptation. Visually, the word consent appears on a dark background. Then, words that do not signify consent flash and disappear. Silence, lack of resistance, intoxication, provocative attire. Myth 29. If a photo or piece of music on the internet doesn't have a visible author or a copyright symbol, I can use it freely. This misconception is rampant in the age of digital content. Many people mistakenly believe that if an image or track is publicly available and lacks watermarks, it's fair game for any purpose, be it for presentations, personal websites, or even commercial projects. This is a significant breach of copyright law. Legally, the author automatically holds the copyright the moment the work is created. It doesn't require any special registration or the visible display of the copyright symbol. C. The absence of an author's name doesn't mean the work is ownerless. It always belongs to a rights holder. Using someone else's content without permission is an infringement that can lead to serious consequences. These range from a simple takedown notice to a full-blown lawsuit seeking damages, which can amount to substantial financial compensation, sometimes reaching 6 or even 7 figures. To use content legally, you must either obtain direct permission from the creator, or you must source materials from sites that distribute content under free licenses, such as Creative Commons, making sure you carefully read and comply with the specific terms of those licenses. Believing the common misconception that Anything you find on Google is free for all can result in extremely unpleasant financial surprises. Visual cue. Imagine a hand reaching out for a photo online. Suddenly, a second hand emerges from the image, gripping the first hand and snapping on handcuffs bearing the copyright symbol C. Myth 30. I don't have to worry about my deceased relative's debts. When a loved one passes away, their heirs are faced not only with grief but also a host of complicated legal issues. Many people mistakenly believe they only inherit the assets, the apartment, the car, the money, and that the deceased person's debts are simply wiped clean when they pass. Unfortunately, that's not how it works. By law, an estate consists of both assets and liabilities, meaning the debts of the decedent are part of the inheritance package. If you choose to accept the inheritance, you must take the entire package, including all outstanding financial obligations, bank loans, utility bills, and private debts. You cannot cherry-pick the assets, meaning you can't accept the apartment while refusing to take on its mortgage. However, there's an extremely important detail here. Heirs are only responsible for those debts up to the total market value of the inherited estate. In other words, if you inherit property worth $1 million, but the deceased had $2 million in debt, creditors can only recover that $1 million. You are absolutely not required to pay any residual debts out of your own personal pocket. If you wish to avoid dealing with debt obligations entirely, your legal right is to simply decline the entire inheritance package. Visually, picture a set of scales. The apartment drops onto one side and a sack labelled debts drops onto the other. The scales balance perfectly, showing that the inheritance must always be accepted as a single combined package. Myth number 31. If I pay a bribe, only the person receiving it is legally responsible. This is a particularly dangerous myth because it creates a false sense of security for the person paying the bribe. The criminal code imposes severe penalties, not just for taking a bribe, but also for giving one. Both actions are considered serious, standalone offences. In fact, the punishment for paying a bribe can be extremely serious, potentially leading to lengthy prison sentences, especially when dealing with large or exceptionally large sums. The law views bribery as a two-sided crime where both parties are equally culpable. There is only one specific situation in which the briber may be exempt from criminal liability. That is, if they actively assisted in the discovery or investigation of the crime, or if the bribe was extorted by the official and the briber voluntarily reported the incident to law enforcement. In all other cases, if the transfer of money or other assets is proven, both the giver and the taker will find themselves standing before a judge. Visually, imagine two hands exchanging money. At the exact same moment, handcuffs lock onto both wrists. Myth number 32. Defending your honour and dignity in court is a drawn-out, costly, and ultimately futile endeavour. Many people facing slander or insults, especially online, simply wave it off, believing that legal action is too much trouble and won't lead to anything productive. This is an outdated notion. Modern legal practice is increasingly siding with plaintiffs in cases involving the protection of honour, dignity, and business reputation. Yes, it requires time and a financial investment in legal counsel, but the results can absolutely be worth the effort. First, a court ruling requires the defendant to retract the false information using the very same method they used to spread it. For example, posting a formal retraction on the same social media platform. This act alone often restores your reputation. Second, you can pursue damages for emotional distress from the perpetrator. The amounts vary, but the simple act of collecting compensation serves as a significant deterrent. Third, if the defendant's actions clearly constitute criminal defamation, the intentional dissemination of knowingly false statements, they can even face criminal charges. Don't allow people to smear your name with impunity. Diligently documenting the evidence through screenshots and witness testimony and consulting a skilled attorney can yield very tangible results. Visual metaphor. Imagine a person splashed with mud, representing slander, stepping under a shower labelled court decision. The filth is instantly washed away. Myth number 33. If I haven't signed an employment contract, then I don't have an employment relationship. Some employers, especially those running small businesses, prefer not to hire employees officially, assuring them that the contract is just a formality. Conversely, employees sometimes assume that if there's no written contract, they have no obligations either. This is a dangerous misconception for both parties, but primarily for the employee. Labour law clearly states that an employment relationship begins not only based on a signed agreement, but also based on the actual commencement of work, with the employer's knowledge or explicit instruction. In other words, if you started performing the job, adhering to internal company regulations, and receiving a salary, even if it was paid under the table, the employment relationship is already established, regardless of whether a paper contract exists. You are legally entitled to demand formal documentation, paid sick leave, vacation time, and all other guaranteed benefits. The fact that you performed work can be proven in court using witnesses, correspondence, and payroll records. As for the employer, this scheme can lead to huge fines from labour inspectors and the mandatory back calculation and payment of all unpaid taxes and contributions. To visualise this, an employee walks onto a factory floor and the manager waves them in saying, "Go ahead, get to work." At that precise moment, an invisible yet strong rope appears between them, labelled de facto employment relationship. Myth number 34. The idea that a search and an inspection are the same thing. While these two investigative procedures are often confused, there is a fundamental legal distinction between them that you need to understand to protect your rights. Inspection, whether it's of a crime scene, documents, items, or a vehicle, is generally a non-coercive action. For example, a traffic patrol officer might ask for your consent to inspect the trunk of your car. You are free to agree, or you can refuse, though declining may understandably raise suspicion. Crucially, the inspection of a home without the resident's consent is only permissible in truly exceptional circumstances. A search, however, is inherently coercive. It is a forceful procedure aimed at finding and seizing instruments of crime, documents, or valuables. A search of a dwelling typically requires a court-issued warrant, except in cases where exigent circumstances apply. During a search, if you refuse to voluntarily open locked rooms or storage areas, the investigator is legally entitled to breach them or force them open. Understanding this difference is critical to knowing how to react to law enforcement. If an officer suggests a more inspection search of your apartment, you have the right to politely decline. If, however, they present you with a court-issued search warrant, you are legally obliged not to obstruct their actions. Visually, imagine two doors. On the inspection door, a police officer is tapping gently, asking for entry. On the search door, the police are smashing the lock and taking the door off its hinges because they have a court order. Myth 35. I haven't been officially served because I never personally received the official notice or summons. Many people operate under the misconception that unless they physically sign for a court summons, a certified letter, or a penalty notice, they are considered non-notified and therefore immune to consequences. This is outdated thinking. Modern legislation and judicial practice adhere to the doctrine of proper service. If a court notice is dispatched to your last known registered address and it is returned marked unclaimed or storage period expired, you are still considered legally and properly served. The responsibility for non-receipt of mail at your registered address rests entirely with you. Courts will not endlessly delay proceedings. They will rule on the case in your absence. Often, the first time you learn about the decision is when enforcement officers seize funds directly from your bank account. This policy also applies to many fines, including automated traffic camera violations. The notification is deemed delivered, and failure to pay means the debt will rapidly escalate. This makes it absolutely crucial to regularly check the mailbox at your registered location and monitor official information sources such as the State Services Portal or the Federal Bailiff Service website. Ignoring official correspondence is a guaranteed path to serious legal and financial trouble. Visualizing this, the mail carrier drops the notice in the box. It sits there, then gets sent back. But from that returned envelope, an invisible thread connects directly to the judge, who simply checks the box marked, duly notified. Myth number 36. I don't have to let utility workers or maintenance staff into my apartment. The owner thinks, my home is my castle, and refuses entry to the electrician, the plumber, or the gas technician who needs to check meters or inspect utility lines. While this behaviour might seem logical from the perspective of protecting private property, it is actually illegal and can lead to serious consequences. The law mandates that the owner must grant access to representatives of service providers for the purpose of inspecting the technical condition of in-unit equipment, performing necessary repairs, and handling emergencies. Of course, they can't simply break in whenever they want. They are required to schedule the date and time of the visit with you in advance. However, if you systematically and unreasonably deny access, the management company or the resource supplier has the right to file a lawsuit. The court will most likely order you to grant access. If you fail to comply even with that ruling, court-martials or bailiffs can arrive and forcibly ensure entry. Furthermore, if an accident occurs because of your refusal, say a burst pipe, due to lack of equipment access, full responsibility and liability for all damages will be placed entirely on you. Visual description. A large lock hangs on the apartment door. A uniformed utility worker displays an official notice, but the door remains closed. In the next shot, a court-martial is seen cutting that very lock off. Myth number 37. Being an official observer is just a formality. You can simply sign and leave. When police or investigators ask you to serve as an independent witness during a procedural action, such as a search, inspection, or seizure, you might be tempted to view it as a frustrating inconvenience. The officer often encourages this, perhaps saying, just sign here and you're free to go. Agreeing to this is a massive mistake. You are not an extra in the background. You are a vital participant, an impartial observer, whose signature officially validates the facts, content, and final results of the investigative action. You are required to carefully monitor everything that occurs, exactly what is being seized, how it is being packaged, and what is being documented in the official report. If you notice any irregularities or violations, you are obligated to object and insist that your objection be noted in the official protocol. If you sign the protocol without looking, and later it turns out that someone planted evidence, such as drugs, or incorrectly described the seized property, your signature legally legitimizes that illegal activity. Furthermore, you can be subpoenaed to court as a witness. You will then have to testify under oath about what you observed. If you state that you saw nothing and simply signed, this could be interpreted as perjury. Serving as an independent observer is not a mere formality. It is a serious civic responsibility. Visual. A person signs a document without looking. A small time bomb symbolizing the delayed negative consequences appears embedded in their signature. Myth number 38. If I commit a crime but then make full restitution, I won't face punishment. Paying for the damage caused by a crime, making amends, is a crucial step that the law strongly encourages. It is considered a mitigating factor and will absolutely be taken into account by the court when sentencing. In some cases, usually for minor, first-time offences, actively assisting in the investigation and providing restitution can even lead to the criminal case being dropped due to active repentance or reconciliation with the victim. However, this is not an automatic outcome. Compensation does not erase the fact that the crime was committed. For many serious crimes, especially felonies, such as murder, armed robbery, or accepting a bribe, no amount of compensation will free you from criminal liability. Your sentence might be lighter, but punishment is inevitable. The decision to drop a case or determine the sentence rests solely with the investigator, prosecutor, or the court based on all the facts. Believing that you can say, steal $1 million, and then, if caught, simply return it and walk away, is a dangerous misconception that has no basis in reality. Visual. Imagine a criminal handing a bag of money back to the victim. The victim accepts it. However, the judge standing behind the offender doesn't disappear. He simply swaps his large gavel for a smaller one, symbolizing mitigation, not the cancellation of the sentence. Myth number 39. The statute of limitations can easily be reset. What is the statute of limitations? It is the fixed period during which you are legally allowed to file a lawsuit to protect your violated rights. Generally, this period is 3 years. Many people assume that if they miss this deadline, they can simply show up in court, claim they had a valid excuse, and the court will automatically grant them an extension. In reality, it is much, much harder. First, the court does not apply the statute of limitations automatically. It must be explicitly raised as a defence by the opposing party, the defendant. If the defendant fails to mention the expired deadline, the court will proceed with the merits of the case. However, defendants almost always bring this up. Second, reviving a missed deadline is only possible in extremely rare, exceptional cases, and only when dealing with individuals, not companies or businesses. The reason for the delay must be compelling and tied directly to the plaintiff's personal circumstances, such as severe illness, incapacity, or illiteracy. And that issue must have occurred within the last 6 months of the limitation period. Excuses like, "I didn't know my rights were violated," or "I was too busy," are usually rejected outright. For legal entities or corporations, missed deadlines are virtually never restored. Failing to meet the statute of limitations is one of the most common reasons a lawsuit is dismissed. Delaying your court action, hoping everything will magically work out, is almost guaranteed to lose you the case. Visual cue. A train labelled lawsuit pulls away from the platform. A person runs after it, but the doors are sealed shut. A judge standing on the platform throws their hands up in resignation. Myth 40. The idea that a prenuptial agreement, or prenup, is only for dividing assets during a divorce. In the public mind, prenups are often seen as something offensive, a red flag of distrust, and only relevant when a marriage is failing. In reality, however, a prenup is a highly flexible and practical tool. It can govern a wide range of marital financial affairs, both during the marriage and in the event it ends. A prenup allows couples to establish joint, co-owned, or completely separate property regimes for all assets or just certain items. For instance, you could agree that the apartment purchased while married is joint property, while one spouse's business remains their own separate asset. Furthermore, it can define how spouses contribute to shared income and how family expenses are handled. For example, who covers the mortgage payments versus who pays for the children's schooling. It can also clearly stipulate which assets each spouse will retain if the marriage is dissolved. A skillfully drafted prenup brings clarity, prevents future conflicts, and protects the financial interests of both partners throughout their entire shared life, not just when it ends. Ultimately, it's a strategic financial planning instrument, not simply divorce insurance. Visually, imagine 2 wedding rings connected not just by the heart, but also by a document labelled Financial Stability, with arrows pointing to icons for home, business, and expenses. Myth number 41. I can bequeath my assets to anyone, and no one will ever be able to challenge it. Freedom of testation is indeed one of the foundational principles of inheritance law. You certainly have the right to distribute your assets as you wish, specify the shares for your chosen beneficiaries, and even formally disinherit any or all of your legal heirs. However, this freedom isn't absolute. The law establishes a concept known as the mandatory share, often referred to as forced heirship. This is the portion of the estate that must go to a specific class of heirs, regardless of what the will dictates. So who is entitled to this mandatory share? This group includes the deceased's minor or incapacitated children, their incapacitated spouse and parents, and any incapacitated dependents. These individuals are entitled to at least half of the share they would have received if there had been no will at all. That is, if the estate were distributed according to the rules of intestacy. For example, say a father wills his entire estate to his current cohabiting partner, but has a minor child from a previous marriage. That child will still receive their legally mandated share, and the will is rendered partially invalid to accommodate it. The assumption that your will is completely absolute can easily lead to your final wishes being executed quite differently than you planned. To visualize this, imagine the estate as a pie, which is initially cut according to the instructions in your will. But then the hand of the law steps in, taking a small piece from every slice and forming a new piece labelled mandatory share. Myth number 42. If I file for bankruptcy, all my debts will be cleared and I'll get a fresh start. While personal bankruptcy procedures certainly offer a way out from overwhelming debt, it is far from a magic wand that solves all your problems without any repercussions. First, the bankruptcy process is complex, lengthy, and expensive, managed entirely by a court-appointed financial trustee. All of your assets, with the exception of your primary residence and certain essential personal items, will be liquidated or sold at auction to pay your creditors. During this time, your bank accounts will be frozen, and the trustee will take control of managing all your income. Second, not all debts are dischargeable. This includes obligations like alimony or child support payments, compensation for injury or damage to life and health, outstanding wages if you are running a business, and debts incurred as a result of fraudulent or dishonest actions. Third, once the process is complete, you face significant negative consequences. For 5 years, you are legally required to disclose your bankruptcy when applying for credit or loans. Furthermore, for 3 years, you cannot hold an executive or managerial position in any company. Bankruptcy is a measure of last resort, not a simple workaround for financial difficulties. Visually, imagine a person dropping a heavy backpack labelled date, but look down, they are still wearing shackles labelled 5 years of reporting to banks and 3 years without a leadership role. Myth 43. If I'm involved in an accident and I'm not the one at fault, the liable party's insurance company will cover everything seamlessly. The Osago system was designed to ensure victims receive compensation. In reality, though, the process is often far from smooth. First, Osago payouts are strictly capped. The limits are up to 400,000 rubles for property damage and up to 500,000 rubles for bodily injury or loss of life. If your luxury vehicle sustained damages totaling 1 million rubles, you'll be forced to recover the remaining 600,000 directly from the liable driver through the courts. Second, insurance companies frequently undervalue the claim amount. The damage assessment is conducted using a standardized methodology which crucially factors in depreciation and the wear and tear of parts. The sum you receive might not be enough for a complete repair. If this happens, you will need to commission an independent appraisal and challenge the payout amount, often escalating the dispute all the way to litigation. Third, the insurer might reject your claim outright if the guilty driver had a fraudulent policy, or if they fled the scene of the accident and were never identified. To assume that the insurance company will handle everything automatically is simply naive. You must actively participate in the entire process, ensuring all documentation is filed correctly, scrutinizing the damage assessment, and being prepared to vigorously defend your rights. Visual. Imagine 2 cars colliding. A stream of money flows from the liable driver's vehicle towards the victims. However, this stream is intercepted by a filter labelled Osago caps and part depreciation, allowing only a fraction of the funds to pass through. Myth number 44. The management company is responsible for everything that happens in the building. Many residents believe that since they pay maintenance fees, the homeowners association or management company should solve absolutely all their problems, ranging from a burnt-out light bulb inside their unit to excessive noise from neighbours. That's not entirely accurate. The management company's area of responsibility is strictly defined by law and by the management contract. They are responsible for the maintenance and repair of the building's common property. This includes the roof, basement, facades, common hallways, elevators, and the utility systems, such as the main risers for water supply, heating and sewage. However, you, as the owner, are responsible for everything inside your apartment. The pipes after the first shut-off valve, the electrical wiring, plumbing fixtures, windows and doors. If a pipe burst inside your unit, you are responsible for the repair and for any subsequent damage caused to the downstairs neighbours. If, however, the main communal riser bursts within the ceiling or wall, that is the management company's responsibility. Regarding neighbour disputes, like excessive noise or smoking in the common areas, the management company can hold an explanatory meeting or send a warning, but they usually lack real enforcement authority. These issues are typically resolved through negotiation or by contacting local law enforcement. Visual cue. We see a cross-section of the building. All common systems such as risers and the roof are highlighted in blue and show the management company's logo. Everything inside the individual apartments is highlighted in red and features the owner's icon. Myth number 45. If I have formal residency registration in an apartment, I can't be evicted. The formal registration of residence, which people still often refer to as propiska, is purely an administrative act. It simply confirms the fact that you live at a specific address. While it grants you certain rights, such as eligibility for social services, it is absolutely not synonymous with ownership, nor does it provide you with an unconditional right to live there. If you are only registered in the apartment and do not own it, you can certainly be evicted by court order. For example, if you are a former family member of the owner, such as an ex-spouse, and you do not hold any title to the property, the new owner or your former spouse following the divorce can legally demand your eviction. There are exceptions, of course, particularly for minor children, or in specific cases where you waived a right to privatisation. But in the vast majority of situations, if you are not the owner, your right to live there rests entirely on the owner's consent. The moment that consent is withdrawn, your right to use the premises is lost. The registration itself will not protect you from eviction if there is a legal basis for it. Let's visualise this. Imagine someone clinging to that registration stamp in their passport as if it were a life raft. But the judge's gavel shatters that illusion, proving that registration is no real guarantee. Myth number 46. A power of attorney grants you the full right to dispose of property as if it were your own. When people issue a general power of attorney or POA for a car or apartment, the grantor often believes they have essentially sold the asset. Likewise, the recipient frequently considers themselves the new owner. Both parties are gravely mistaken. A power of attorney is definitively not a transfer of ownership or title. Instead, it is merely the authorization for one person, known as the principal, to allow another person, the agent or attorney in fact, to conduct specific legal actions on the principal's behalf. The agent is legally required to act strictly in the principal's best interest. For example, the agent cannot use the POA to sell a property to themselves or their spouse at a reduced price. Any such self-dealing transaction would be deemed invalid. Furthermore, the principal maintains the right to revoke the power of attorney at any time, instantly terminating all the agent's authority. And most critically, if the principal passes away, the power of attorney immediately becomes void. The asset will then enter the deceased's estate, and the buyer by POA will be left with neither the property nor their money. Using a general power of attorney to execute transactions involving real estate or vehicles is an extremely dangerous and high-risk scheme. Visualize it this way. One person hands another a key attached to a keychain shaped like the POA document. But from that key, a thin thread extends back to the original owner, a thread they can snip at any moment. Myth number 47. If my boss yells at me, I just have to put up with it because, well, he's the boss. Workplace relationships are governed not only by labour law, but also by administrative and sometimes even criminal law. Your manager certainly has the right to assign tasks, demand their completion, and apply disciplinary measures for misconduct. But they absolutely do not have the right to make personal attacks, insult you, diminish your human dignity, or use obscene language. Such behavior violates your basic constitutional rights and can be classified as harassment or defamation, carrying administrative liability, usually in the form of a fine. If the yelling is accompanied by explicit threats, this could lead to even more serious legal action. You are under no obligation to tolerate this behavior. What steps can you take? First, try to document the insult. Record the conversation using a voice recorder, or find colleagues who witnessed the event. You can file an official report with higher management, or appeal directly to the Labour Inspectorate. As a last resort, you can file a complaint with the police or prosecutor's office. Being a subordinate at work does not mean you have to sacrifice your human dignity. Visual: a boss is yelling at an employee, and abusive words are flying out of their mouth, but the employee puts up a shield labelled "Harassment is illegal," and the words bounce right off. Myth number 48. Debt collectors can show up at my house and seize my belongings to cover a debt. Debt collection activities generate a lot of fear, and the major concern is that they will force their way into your home, inventory, and confiscate your property. This is absolutely illegal. Collectors are employees of private commercial organisations, and they possess zero governmental authority. They are not bailiffs or court enforcement officers. Legally, all they are permitted to do is inform you of the outstanding debt. This includes calling you, subject to limits on frequency and timing, sending texts and letters, and offering repayment plans. They are strictly prohibited from threatening you, applying psychological pressure, or misleading you. And critically, they absolutely cannot enter your residence without your explicit consent. Only court enforcement officers are legally authorised to seize assets to settle a debt, and they can only do so with a valid court order as part of an active enforcement proceeding. If individuals arrive, identify themselves as collectors, and attempt to enter your apartment or take your property, immediately call the police. Their actions may constitute unauthorised self-help, trespassing, or even theft. Visual cue: a collector knocks on the door. The door displays a large "Stop" sign, and below it the text, "Only with a court officer and a judicial ruling." The collector sees the sign and leaves. Myth number 49. Any contract I sign is unbreakable and absolutely binding. Putting your signature on a contract is undeniably a very serious step that creates legal obligations. However, this absolutely does not mean that every document you sign becomes sacred scripture or an immutable truth. The law provides numerous grounds under which a contract can be invalidated, either voidable or completely void. For instance, a contract can be nullified if it was signed under duress, threat, fraud, or through exploitation, meaning it was signed under extremely unfavourable terms due to severe financial or personal distress. Furthermore, any agreement that contradicts public policy or basic morality can be deemed invalid. When dealing specifically with consumer contracts, if the terms contained within the agreement infringe upon the rights guaranteed by law, those specific terms are automatically void and unenforceable, even if you sign them. A classic example: a clause in a dry cleaner's contract stating they are not responsible for damaging your clothing is illegal and holds no legal weight. Don't be afraid to challenge unfair contracts. If you believe you were defrauded or taken advantage of, you have every right to take the matter to court. Picture this: someone signs a document, but then a judge examines that contract under a magnifying glass, and certain clauses, especially those written in fine print, start to smoke and vanish, proving they are completely invalid. And finally, myth number 50. Legal services are only for the rich or for people facing huge crises. Many people avoid lawyers, believing it's an expensive luxury, and instead try to solve complex issues themselves using online advice. This is essentially trying to treat a serious medical condition using Wikipedia articles. Yes, legal services cost money, but the consequences of making a legal mistake can cost 10 or even 100 times more. Losing your home, a failed business venture, or facing criminal charges. That's the price of overconfidence. However, You don't always need an expensive consultation with a big-name attorney. There are many ways to access legal help. Governmental legal aid offices that provide free assistance to specific categories of citizens, law school clinics, and online services that can help you draft a simple contract or complaint for a modest fee. Prevention is always cheaper than cure. Timely consultation with a lawyer before signing a critical document, before a major transaction, or right at the start of a conflict can save you massive amounts of money, time, and stress. Investing in legal literacy and timely professional assistance is one of the most justified investments you can make in your life. Visually, imagine this. On one side of the scale, there's a small stack of coins, the cost of a lawyer's consultation. On the other side, there's a massive pile of problems, a house on fire, a wrecked car, and the judge's gavel. The first side easily outweighs the second. So there you have it, all 50 myths debunked. As you can see, from misunderstandings about self-defense to misconceptions about your digital footprint, legal pitfalls are waiting for us at every turn. Some of these myths seem harmless, but believing them could cost you money. Others, as we've learned, could potentially cost you your reputation or even your freedom. The main takeaway here is simple. Do not rely on rumours, Hollywood movies, or internet speculation. Your freedom and well-being are far too valuable to risk due to legal ignorance. Study the laws, and when in a difficult situation, don't hesitate to consult a professional. Thank you for watching this crucial video all the way to the end. If you learned even one new fact that could protect you in the future, then our work here was worthwhile. Be sure to hit the like button and subscribe to the channel so you don't miss our new myth-busting content. And don't forget to ring that notification bell. Now for the most important question, which of these 50 myths did you personally believe was true before watching this video? Write the myth number or its core concept in the comments below. Let's see which misconception is the most common. Stay informed and stay safe.